For those who don't know the people who are in attendance right now, we have Claudia Bowser Medeiros, who will be speaking on issues of international data transfer in the context of Brazil. She's a full professor of computer science at the Institute of Computing at the University of Campinas in Brazil. We also have Dara Halonen, who is a lawyer and academic based in Germany, who will be discussing these issues from an ethical and legal perspective with an emphasis on international data transfer in the research context. And we also have Diana Dimitrova, who is also a Germany-based academic and a legal researcher who will be discussing international transfers as well. Lastly, we have Simon Parker, who previously worked for Cancer Research UK and will be discussing the similar issues from a more technical standpoint. So without further ado, I will leave the floor to the first of our speakers, who I thought Dara, or was it Claudia? Claudia, were you starting? Claudia, sorry, you're on mute.
The end said that I would be the first, so do you want me to start?
Brilliant. By all means, and would you like to share your slides, or otherwise
yeah,
I can...
for sure. I'll present my screen. Just let me know when you can see them. Can you see my slides?
Yes, we can.
Okay, so I'm from Brazil and it's morning here, 7 a.m. And good morning to all of you. And I'm just going to present the main issue. My case study is the whole country, okay? And the main issue is our very new LGPD law, which is a general data protection law, which was voted in 2018, but began to be applied as of mid-2020, and it's inspired by Gdpr. And what is happening here, everywhere, where research comes in focus, is that we have two sides. And here I'm showing you the colors of our two most popular teams and the classic soccer game, Flamengo, which is my team, and Fluminense, and we call it Fla-Flu. And here the referees are the ethics committees who still do not know how to deal with this new law. So in these two sides, we have the team of those who are the data sharers, and they are either those who always share data or those that are attracted by the fact that more and more you share, the better it is, open science. So both of these, the old ones and the newcomers, are grappling with lots of implementation, legal and ethical issues. On the other side are two kinds of players, let us say, those who never shared, and they are very either happy or in the status quo. And those who used to share, but because of the new law, they've moved to the non-sharing side because they're afraid of penalties. What's the actual situation here? So as concerns health research data sharing. So first of all, the big discussion on the meaning of consent and the pro-sharing are modernizing consent forms so that they include relatives of the patients so that everybody is happy, not only the patient, but the relatives as well. Whereas on the other side, you have those who are closing files that were previously open health data for fear of penalties. And then the implementation. Of course, I told you the law, 2018, we still don't know, nobody knows how to implement it. Big discussions involving the ethics committees. Does it apply to research data or not? How and where to find data protection officers? This does not exist. Nobody got prepared for this implementation so that everybody and everywhere is ready to find data protection officers, but nobody knows really what they should do, and not enough legal experts. And as a last slide, I'm working in a major COVID-19 repository that has now open repository, over 20 million records of exams and 400,000 Brazilian patients, not only those who have COVID, but those who tested negative or positive for COVID. And this is a federation of repositories in which hospitals are data providers. They clean up their data, pseudonymize the data, and then the data is provided to the world. What is happening? We have those who already provide the data that are considering closing data, so they are the ones that are changing teams. And we have those that never share their data, and they are now sharing the data, and they are opening up. So my whole discussion on soccer and referees is based on this real case study. And I'd actually be very grateful if I could get input either now or afterwards from people who have experienced sharing millions of clinical hospital patient data. I now stop sharing. I hope I haven't exceeded my 5 minutes, and pass it to whoever is moderating. I finished. Over. Okay. Okay. Everybody, where is Alexander? So, are there any questions?
Claudia, I have a nasty feeling Alexander has actually dropped out of the room.
Yeah, so he was replacing Anne. So let's
yes, sorry, I got kicked out of the room for a moment there. I'm not sure why. But Claudia, thank you for a wonderful presentation. I think that everything that you speak to seems to be a, if you will, a recurring theme amongst countries that are starting to implement data protection legislation that's very much based on the European model, and importing it into a legal or a cultural context that isn't necessarily accustomed to the use of these laws. And I think it's very interesting to see, as you've said, Brazil moved from a situation where it has, and I may be wrong about this, but from what you've described, it sounds like it didn't previously have a data protection law that looked anything like the General Data Protection Regulation, and then moved to a context in which it had a very strenuous, very, very rigid data protection law, such as...
I may interrupt, this is almost for biodiversity data. It was all very regulated, and now it's being all messed up because of our General Data Protection Law. I'll just mute myself because the session has to continue. Thank you.
Well, thank you. And so now I'll turn the floor to Simon, who will be discussing the German and United Kingdom perspectives on data stewardship in the age of data protection and international transfer. So Simon, I'll leave the floor to you if you have slides to share. Oh, I see they're already up. Fantastic.
Thank you, Alexander. So I'm going to be talking to you today on the project COGDAT, and more generally on data sharing in Germany, and how I feel that perhaps the situation that we have in Germany at the moment is really a microcosm of multinational issues with regards to data sharing. So hello everyone, my name is Simon. I'm data steward at DKFZ, which is the German Cancer Research Center. But I'm actually part of a project at the DKFZ called GHGA, which is the German Human Genome Phenome Archive. So I'm going to be talking about a project that we've recently been involved with called COGDAT. Now, in Germany at the moment, a small percentage of patients who test positive for COVID-19, their test samples undergo genomic sequencing, and this data is eventually processed so that only the viral information is retained. We're not really particularly interested in the human reads. We really just want the viral consensus. And it's varies across the country, but it's approximately 5 to 10% of positive tests to sequence. And these are then archived if they have a very low degree of missingness. So again, it's approximately as long as the sequence has no more than 5 to 10% missingness, it's archived. If it's greater than that, then the data is essentially destroyed. Now, I'm based in a state down in the southwest, Baden-Württemberg, as is Dara and Diana. And Baden-Württemberg has actually announced a plan to sequence 100% positive tests and then augment this with further information that's collected so that we can start looking for things like the individual changes in the data. So when we've just got the viral consensus and very little other information, it's hard to tell whether there's been within individual changes, and this is becoming increasingly important as we see the evolution and change in the variants of COVID that we're seeing. And the project that I'm involved with, because we work with genomic data, we were asked to help support the development of a new genomic archive for COVID data. Yes?
You were not changing your slides, are you?
Not at the minute. What slide is showing?
The first one, the very first one.
Oh.
So
I'll try sharing again.
Yeah, I think you're sharing the wrong. Well, here, if you try it again, let's see what happens.
It's not the most intuitive thing, is it? I'll tell you what, I'll share the entire screen and then hopefully that should...
Yeah, if you share the entire screen, it's best. Yeah, there you go. It's more
there we are.
Working.
Fantastic. So yes, GHJ was asked to support the development of a new genomic archive for COVID-19, which is what we're calling COGDAT. And this work is being led by the Kohlbacher team at the Tübingen University. Now, this does present some legal challenges. So the sequencing labs obviously are going to be required to do far more testing than they have been previously. And so what we proposed was that the COGDAT assisted in the processing of the sequencing data. So as I mentioned, we're only really interested in the viral reads, so the genomic data relating to the virus, but the sort of raw data will contain human genome reads as well. It's just part of the collection process. I should caveat this to say my background's Renaissance history, so I do not know that much about genomic data. This data would be considered personal and special category data under the GDPR because it's human genome data, and as such, we needed to find a legal basis for this proposed processing so that we could actually handle that raw data. Now, GDPR in Germany is somewhat complex. So there's the Federal Data Protection Regulation, which is the BDSG. However, each state has its own data protection law as well. So if we go back to our map, we have 16 states in Germany, and so there is essentially 16 data protection law acts in place, and then a federal one which refers to certain organizations. In Baden-Württemberg, we didn't have a suitable legal gateway for COGDAT implemented. Essentially, we didn't have anything that we could use, such as legitimate interest, that would be suitable for this particular project. And as such, we were unable to find a legal basis for the project as we proposed it. So what we've had to do is actually just change the way that the project works, and so that the processing will continue to be done at the sequencing labs. And so we'll only be receiving the consensus viral reads, viral sequences from the lab. So we're not going to be involved in any of the processing of the personal data. Now, really, I felt that this was a sort of a microcosm for issues around multinational data sharing. And although there are potential legal bases that exist in the GDPR, many of them require implementation at the member state level. So things like legitimate interest, for example, is the one I was most favored to use. That needs to be implemented at the member state level. In Germany, we have further complication in that we have a difference between federal states in theory and also a difference between the federal level legislation. And so we need to have legal bases that align for transfers to happen between federal states, and then again for between member states under the GDPR. Consent is sort of one of the ones that's available by default, and so it's most often used as the legal basis. It's not always the best one, but it is always available, and so that's why we tend to have the transfers of data under that as the legal basis. Now, of course, during COVID, being a public health emergency, it's slightly different. It's slightly more difficult. And for our project, although we're able to find a way to go forward, that won't always be the case. And actually, we suspect there might be some impact on how successful the project is going forward. Having to rely on consent generally will require a certain amount of pre-planning because you're collecting consent prior to the data being collected, and that won't always be possible during a public health emergency. By their very nature, they're emergencies. We may not know, well, we don't really know that they're coming, and so that makes it difficult to go and get consent for research use of data prior to the event happening. Consent may also fail the specific and informed requirements, as public health emergencies may not be adequately described when the consent is given. So consent is required to be specific and informed. And if we don't know what the public health emergency is, it can be difficult to have a consent which meets that specific and informed requirements, whilst having the flexibility to enable the use of data during public health emergencies. And so what my view is that member states may need to implement other legal bases more broadly, so that we have that alignment between member states. And so during public health emergencies such as COVID, we're able to have those transfers of data. We're not sort of reliant on consent, or in our case having to work around the fact that we couldn't have the personal data in our archive. And so really that's all I wanted to talk about today, or to highlight, and really showing hopefully that the situation that we've had in Germany with the divergence between the various states of Germany, and how that impacts and is reflective of challenges that we see data sharing across Europe, even though we have the GDPR. So thank you very much.
Simon, thank you for a riveting talk. I think you're one of the people here who has the most experience really dealing with those practical nuances of GDPR transfers, even within Europe, in a sort of applicable, practical way. Two things that I maybe wanted to ask you to follow up on your talk were, first, have you seen the discourse change a lot on the field as the pandemic runs its course? And specifically, have you seen maybe different member states respond differently to this pressing need to share health data?
I mean, my experiences are obviously from being in the UK. So I was working in the UK when everything started. So yeah, international move during a pandemic was a brilliant idea. And so I have some experience of Germany now, and compared to the UK. I think the reaction in the UK was they brought forward ideas around COPI, which was to sort of try and accelerate some of the data sharing. It's slightly different in that although health services are largely divided and data collection is happening at England, Scotland, Wales, and Northern Ireland level, the laws are not quite so different between them. There are some differences, but it's not quite so pronounced. And so that system seemed to work very well. And the message that we had from the ICO, the Information Commissioner's Office, which kind of oversees the use of data within the UK and data protection legislation, was very much along the lines of, if you're working with the right intent, even if you don't necessarily get things 100% right, they would kind of be not necessarily letting things slide, but they're not going to be quite so strict on everything being exactly perfect. They understand that this emergent problem. People are handling data who may not be necessarily familiar, and organizations may be providing data for the benefits of the response to COVID in a way that they're not used to. And so there was a certain amount of leeway given, whereas what I found so far in Germany is been much more about what's been consented. It's very much the focus of the work that's done, and it always goes back to that issue of is there consent for this, and if not, it is making things more challenging. So not saying that one's better than the other, but it did seem that the ability to share data was somewhat easier in the UK than I've found it so far. But I've only been here since December, so.
Well, thank you, Simon, for that really interesting answer. I see that Robin here has a question of her own, which is about the public interest basis for transferring data from the UK to or from Germany or another member state outside of the EU or the EEA. And I guess it's interesting to consider, has public interest been used or considered as a justification for outbound data transfers? And if I might forward on that, I'll go ahead.
Yeah. Robin's followed up, so public interest if not consent, I mean. So yeah, I mean, so the way that, for example, the organization I was based at, the UK, handled that was that we primarily access data using legitimate interest, because we were a cancer research charity, so our role was researching cancer, and so we would argue that we had a legitimate interest to access patient level data in order to do that work. Now, my view is that as researchers, we tend to be somewhat biased. We don't undertake research that we don't think has value, by and large. And so what we would do within CRUK was that we would speak to patients and actually utilize a patient involvement network to ask them, do you think that this is a legitimate use of patient data? And what we would do is then, respond to whether they felt that that was a legitimate interest, and that would support when we were making applications for data. I haven't seen that so much in Germany, but equally, I've only been here a short time. It does tend to be much more on what's being consented.
So on that note, then I might turn the floor. This seems like a good segue into the presentations of both Dara and Diana, who are lawyers based in Germany who address these issues in their work from both an academic legal perspective and a practical legal perspective. Thank you, Simon. Dara, Diana, if one of you would like to share your, there we are.
Sure. I think Diana's down to go first on the schedule, but I don't know where she's gone. So if she's not here, I'm happy to jump in. Okay.
All right, I don't hear a response from Diana. Oh, there we go. We have Diana.
I thought, Dara, you go first. Dara?
Yes?
I thought you go first, but if you want me, I can continue, no problem.
That's fine. I think you're first on the schedule, so maybe we stick to it.
Okay, great. I'm just about to start sharing my screen. So I'm not sure of, okay. Oh, okay, I don't know why I'm not able to share my screen. I clicked on the share desktop icon and...
Sorry, Diana.
Can we now?
Yes, I can hear you loud and clear.
Well, the one sharing the screen before has stopped sharing before it. So I don't know if Simon has...
So I think Simon's screen is off. Diana, if you're having trouble sharing the screen, I'm happy to share your slides. Alternatively, if Dara's slides are ready to go, we could potentially, in the interest of time, we could have Dara present his slides if screen sharing works. Oh, Diana, oh, there we go.
Oh, it started working just now. Wait a second.
Then, yeah, absolutely. Go ahead.
Sorry about these technical issues. Okay. Are you able to see my slides?
That's perfect. Thank you.
Can you see my slides?
Diana, we can see the title page, so we can see the mode.
Oh, you can see the title page. Amazing. Okay, great.
Okay, now,
All
sorry,
right.
now oh, there we go.
Sorry about this technical issue. Okay, so hello everybody. My name is Diana Dimitrova, and I work. I'm a data protection. I have a background in data protection, and recently with the COVID crisis, I got engaged in working more on health topics. And I would like to share in my presentation a bit of my experience when working with, as a data protection expert, when working with non-data protection experts, very often data stewards or medical and clinical researchers. And I would have picked a very specific topic, which is how we, as both legal experts and the more technical or health oriented researchers can work together in order to define in the first place whether we are processing a certain project is processing personal data. Now, in my presentation, I will first explain to you why this question is important before I give the floor to Dara about how we overcome the legal issues of personal data transfers. I will show to you where the problem is coming from the GDPR, how in practice, in clinical and health research, this problem is coming, and I'll suggest possible solutions to open up a discussion if we have time for this, of course. Now, why did I pick this question and why do I think that it is important? Now, in this session, we have been discussing a lot of important legal and ethical questions. And when we talk about legal questions, especially how to comply with the GDPR and tick all the boxes about its different requirements and provisions, we first need to define whether we are processing personal data. And this is not necessarily that straightforward, especially in the more health and clinical research context. Now, what clinical researchers, what health researchers need to know is a clear yes or no. Does the GDPR apply to us and to what we do or not? Because if it applies to them, they need to comply with a lot of requirements, and if it does not, they do not need to comply with the GDPR. But believing that they have to comply with the GDPR puts unnecessary work on them. Now, Now we know how important this problem is. Let me show to you what the provisions in the GDPR are and why we are having this problem in practice. Now, theory is easy, practice is more difficult. Now, the GDPR applies when we process personal data. And personal data in the GDPR is data which relates to identified or identifiable persons. And this identifiability could also be indirect. So if we are working with pseudonymized data, which have then the ability to be related to identifiable persons, for their identifiability to be traced back, then the GDPR continues applying. However, if we're data where there is no risk of identifiability, the GDPR does not apply. And exactly at this intersection of is there this identifiability risk is in practice a bit difficult. Now, in the health context, health research, clinical research context, we have another level of difficulty. It's because, as you can see, according to the GDPR, data concerning health belongs to the special categories of data, and the requirements when it's processing, which means collection, storage, transfer, are much stricter. In principle, the processing of such data is prohibited unless a certain exemption applies. And one of these possible exemptions, it could be scientific research. But again, the question stays, are we processing personal data or not? Now, an example, like if we're talking about biological samples. Now, I was once confronted with the question that somebody intended to process biological samples, and I was confronted with the question, is this personal data and does the GDPR apply? And as well as I knew the theory, as I presented it to you, it was not such a straightforward answer. My colleague Dara Hallinan and one of his colleagues, Rafael Gellert, wrote a nice paper where they tried to illuminate, to put more light on this question. And they do say that that if we have information which is stored in biological form, which could be could be contained in biological samples, and we are talking here about data processing, and the GDPR should apply. Now, in this paper, they also presented arguments against those who against those arguments, arguing that the GDPR does not apply. Now, there are three main arguments were that very often, if we're processing biological samples for the mere purpose of working with the genomic data, there is obviously this identifiability risk, and the GDPR should be applying. Now, they also argue that without regard to whether the DNA samples we are working with in these biological samples are secret or not, we are still processing personal data because the GDPR or in the preparatory words on the GDPR are never meant to exclude such type of biological information. And then we are also seeing, as a third point, that the Court of Human Rights, a very court with very influential jurisprudence, has argued in a series of cases that especially DNA biological samples, they contain sensitive personal data, and that, of course, because of the sensitivity of the data and identifiability risk, they should be processed as treated as personal data. Now, this is my last slide is how to overcome this advice problem in practice, which means how to make sure that ethical and legal researchers who are guiding a certain project and the more medically oriented health scientific researchers can have both clear information and collaborate in order to establish in the first place is this personal data, because very often we have technical knowledge, especially when we are confronted with such technical details, in order to give a plausible assessment, a very clear yes or no. And on the other hand, we know that technical people need this very clear yes or no, and that they need probably a bit more patience in explaining and reaching this conclusion. So that's why I here put just as a starter for the discussion, if we have time for it, suggesting that a data protection and ethical person should be involved from the very beginning. Then there should be very open discussions between both sides, where we, the data protection people on one hand, explain how important this is and how difficult it is to find a yes or no answer to this question, and get all the technical information that we need patiently explained. And then, because the GDPR puts a focus on the identifiability risk, we always have to stay up to date with the new technologies in order to see that whether, if we assess that something is anonymized data, how soon there could be this re-identifiability risk, and whether the approach should be changed. I think I've taken my time. I thank you for listening, and I'm ready afterwards for questions or discussions, and then I will disappear so that Dara can continue.
Thank you, Diana, for a really interesting talk. I think that you've really highlighted some issues that everyone is facing around the world, and specifically the relationship between the technical and scientific questions that come up in assessing things like identifiability and data protection, as well as the more theoretical legal ones, and how it's very difficult to often cross that barrier without doing a lot of thinking and a lot of research. I see the time, and so I might move directly to Dara's talk and then address questions to both of you in participation with the audience. So Dara, if you have slides to share, by all means, you're welcome to share them and dive right in.
Okay, can you all see my slides? Hello?
Yes,
Oh.
yes, Dara, I can see your slides. Or I can see the main page. If you're in presenter mode, I can't see that, but I can see the what would you call it? The slideshow. So
Hello?
Yeah, we can see you, hear you. Show your slides, please.
Okay. Can you see my slides now, everybody?
Yes.
Okay, perfect. All right, so this isn't really a case exactly. It's just an observation and maybe some food for thought about how we go about thinking of and treating the law in relation to international research transfers of personal data. So when we look at the law, we usually expect or we usually hope that it's going to embody certain values. So for example, that the law is going to have some relevance and proximity in relation to the actions that it's regulating, or that we're looking at it to regulate. And that the law is going to be cogent, so in the sense of being internally coherent, and it's going to be consistent in the sense of providing a framework through which we can coordinate our actions and order processes moving into the future. I think, however, while we normally look at the law in relation to international transfers of personal data in light of these traditional values it should have, we should be a little bit more cautious in applying these expectations in relation to the law governing international transfers of personal data for research. And I'll run through the two values I listed here just as an example of why that might be the case. So in relation to the proximity and relevance of law to international transfers of personal data for research, the law on personal data transfers is a really, really young area of law. At least in the EU, it hasn't really been designed with research transfers in mind. Actually, it's been designed at a much, much more general level to be applicable to all forms of transfers of personal data across boundaries, from banking data to social media data, and then including research data. So the expectation that the law as it is on the pages of the legal texts and in jurisprudence is going to provide answers that are specific to research and going to sort of provide perfect balances is a little bit flawed from the start, and a dangerous way to think about how the law approaches this kind of issue. And in turn, the law is influenced in its development by a series of really quite conflicting high-level political trends. And none of these specifically relates to research, or they tendentially haven't up to now. That might change with COVID, but I don't want to say too much on that. For example, you have economic and bureaucratic needs for the harmonization of data processing conditions across jurisdictions. So economically, it would be great if the EU and the US could freely exchange data with the minimum of bureaucratic and legal barriers. So on the one hand, and on the other hand, you have political desires for jurisdictions to retain data sovereignty, to keep control over what happens to data relating to their citizens and how it's processed when it leaves jurisdictional boundaries and borders. So in relation to cogency and consistency, then, so the cogency and consistency in law essentially emerges when law regulates a stable set of actions and relationships against a stable normative framework. So we have to know basically who's doing what with what to whom, and we have to know what we think is okay and not okay in relation to those actions. Then we can have stable law. International transfers of personal data generally, and this includes research transfers, raise new forms of possibility of engagement between individuals and between individuals and social systems, and between those individuals and social systems and the social systems and individuals located in other jurisdictions. The base set of interactions are not yet stable in relation to personal data transfers across jurisdictions. And in turn, societies are really still coming to terms with the way in which personal data change the ways in which we interact. We don't know the consequences of the processing of personal data, the social consequences, what this phenomenon will turn our societies into and why, and the causal relationships that are going to make those changes happen. And for that reason, the relative or the relevant normative frameworks that we're working with are also not yet stable. So we don't have a clear, perfect ethics of what is going to be the right limitations on the processing of personal data, including research data, such that we maximize the benefit we're going to get from it and that we minimize the potential harms that we see coming from it. And in this regard, law is, because of this uncertainty, subject to considerable fluctuations as different processing constellations emerge and disappear. New intermeshings of systems, particularly international legal systems, have to happen. And as perceptions of what counts as a correct normative balance, so the correct balance of right and wrong, legitimate and illegitimate, between these interests shift, and these new constellations, these new perceptions, these new balances drive new interpretations of black letter law. So we just look at the law and say, it's this paragraph that's the problem. Actually, often it's the way that people have been interpreting the paragraph based on certain political or interest-specific intentions they have. And what does this all mean? Well, as above, that it means we should be a little cautious in applying traditional expectations of the law in relation to the law governing personal data transfers for research, and for the foreseeable future at least. And obviously, this comes with some negatives. So this is not the ideal legal construct within which practitioners are going to be able to plan their activities personally. But we should also remember that this flux, this legal flux, is not necessarily all bad. In the first instance, this means that the law is really now being shaped. It's going to be shaped in multiple jurisdictions, multiple sort of regulatory nodes, and by multiple actors. And there are still opportunities to bake in research-friendly procedures and principles that I see. And in turn, we should also remember something Alexander brought up at the beginning of the discussion, is that we look at the law as it is and we say, it's causing all these problems. We should remember that in a situation of extreme uncertainty, or at least significant uncertainty, it's going to be very difficult to design a law that doesn't cause problems. We should remember that when we're passing judgment on the laws that we have, and remember that there are positives in there as well as negatives. So that's it. Thank you for listening.
Diana, thank you both for a really fascinating series of talks. Before we dive into the main discussion, I would maybe have one follow-up question for each of you. I think there were some common themes there, and one of the themes that stuck in my mind was this relationship between what people do in practice and the sort of theoretical abstraction that is the law, and how the closer the law is to what people are actually doing, the easier it is to navigate those boundaries. So for Diana, my question would be, do you think that the way data protection law is framed, both in terms of identifiable data, lawful bases, and other procedural obligations, is close enough to the actual practical activities of scientists that in the near future it will be able to easily answer these questions of identifiability and of data use once people get used to them? Or do you feel that the concepts are maybe so disparate that it will actually be difficult to navigate these different normative frameworks?
The answer, I think that, Alexander, the law, I mean, the GDPR is logical in that sense that if we want to protect personal data and people can suffer from harms when they are identified in a certain way, this is perfectly logical on a theoretical level. What I find difficult, though, is with the changing of the technologies and the changing capabilities of in terms of identifiability, we will be having, in my opinion, a bit of less certainty. Like I said, if we assume that today we're processing anonymized data, this could be treated as pseudonymous a year later or 5 years later. In that sense, the GDPR is good because it's flexible and it gives criteria about how to assess this, to assess classify personal data. But this flexibility is at the same time leads to a bit of uncertainty in the longer term in the future. So I think in practice, the problems, in my opinion, will not be disappearing, but I hope I'm wrong about this.
Can you hear me? That's Adam.
Yes,
Yes, we can.
Yes. Okay. First of all, I would like to thank you, my co-pilots of this session, to have taken over all the technical issues I had, which was making that I could not be heard, could not be just could be seen or not, and could not share my slides. So before we go into the second part, which is the interactive part, I propose to recall what is the aim of this session and locate all these issues in the general framework of our RDA working group and what we try to achieve where we are now, if you all agree. And just when I hear, you have heard, audience, you have heard distinguished legal experts. I'm not one of them. And taking the hat of the ordinary scientist, I'm quite terrified of hearing about all these uncertainties, difficulties, complexities for lawyers themselves. So if we could bring some recommendations or as a result of not only this session, but the following up working group, in order to help the ordinary scientist to know where to go, what to bring as information, not too much, but enough about the technology, to whom, and what is the framework where the simple question, what do and export, or how can I give access to this and this kind of data, which is the simple between bracket question that most scientists have. I think it's a bit disturbing to see all the uncertainties that the legal experts themselves see in the law. So what should the scientists do? So is it okay if I share some slides now?
Yeah, go ahead. Go ahead. And we seem to be hearing your audio in double those last few seconds, but I think it's gone away. I think you're good. Oh, no, it's still in double, but we can hear you. And yeah, please go ahead.
Okay,
share your slides.
Good. No, that's not what I wanted to share. Okay, so that's what I want to share with you. Do you see the slide? Or not?
Yes, 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 yes.
Yes, okay. So that should have been the introduction of the session. And I will go very quickly about it. I think it's important because we try to achieve something. The practical information, you have got the link to the collaborative notes and what is very important, if you agree to that, is to give your name and how much you want to contribute to the working group. In this document, where I have two other important things, the agenda and who has talked and so on, and also the fact that we are trying for the moment to set up consultations, and in the second part of this session to help setting up this questionnaire and what questions seem legitimate or interesting for you. So to have just a little bit of mapping of this session and the work of the working group, this, which is linked to COVID-19 Legal and Ethical Act for sharing data was created in 2020 as part of the general action of 19 data sharing of the RDA. We had a first step in the work, which was to contribute to the large document that has been adopted in June 2020 by RDA, and many people in the contributed to that. We, after June, continued the work and working on international data sharing for health research more broadly than just in epidemic. And that's where we are now, and is part of it, where we try to deepen or improve or add recommendations to those already produced in the light of two elements. First of all, there are new issues in relation to vaccine, which was not approached in the original document, and there will be a session tomorrow on that specifically, and then recommendations or possible recommendations based on case studies. Here comes the questionnaire I was alluding to. This is just to remind you where this working group is located in the general COVID-19 related work in RDA. And you have already done without me, or just being present for the last part. The part of this session on the presentations, which were supposed and that beautifully illustrated, expose the issues related to legal or ethical aspects from different points of view. The researchers, that was Claudia, Stuart, or data managers, Simon alluded to, and then from the legal or policymaker more point of view, and that were the two and Dara. And of course, there are other stakeholders like funders and editors. We could not multiply that too much. But they have a role to play in the implementation and control and follow-up of all these issues. Now we are in the interactive discussion, and in the collaborative notes, where you link on these slides and the chat, there is pasted the question as it is for now. We don't have time to go through all the questions, and what I propose to you is actually to just go and try some of them and see what it gives if we try to answer them. So that is another experiment. You have here a link, livevoxvote.com. If you go on this link and type the PIN, which is indicated here, maybe somebody can put that in the chat. You will be able to vote and to see some of the questions. So what I propose, and we can also have a general discussion, is after some discussion to spend a quarter of an hour in looking at those questions, those questionnaires. So that was all what I wanted to tell you. It should have been in the beginning of the session, but I think it was still timely to share that. So I will stop sharing my screen or change at least the slides. To go to the
Claudia, I've logged into livevoxvote.com, and it's waiting for questions.
Now, let me see.
Okay. So I will. Oh.
And I wonder if while we set that up, if it might be a timely moment to ask the audience
Absolutely.
if they have
Absolutely.
some questions while we set that up. So if anyone in the audience has a question for one or all of our speakers, feel free to drop it in the chat, and our speakers will be very happy to answer. In the interim, if there are no questions in the chat as of yet, I was curious to hear from Dara. Let's see. No, we still don't have a question. So Dara, I was curious to hear from you whether you think that the exercise of engaging with this process of data privacy compliance, which can be very challenging, will itself start to develop a culture of data sharing that sort of respects scientific interests and ethical and legal privacy interests. If you think that there's sort of, I guess, an inherent value in this process of trying to figure out data privacy law.
Can you hear me?
Yes.
Yes. Oh, perfect. Alexander, absolutely. Like, without any shadow of a doubt in my head, where you have uncertain interpretations and vague or abstract law, this leaves space. I mean, the intention of the GDPR was to leave space further down, more sectorally specific in relation to specific processing activities for sui generis and more accurate, more subtle approaches to be developed. I would hope that the activity of compliance itself, or efforts to comply, efforts to shape logical balances between various interests done by scientists or DPOs or ethics committees who work more in closer connection with specific research projects or specific endeavors, are going to come up with ideas which then filter up as logical to higher levels of interpretation of the law, and then which are taken as simply the standard by which the law itself should be judged. I also think it's really very, very important that the research community in general, I'm not talking about specific researchers trying to come up with compliance solutions for specific projects, but the research community in general engage in advocacy and engage in the construction of possible solutions that are going to both take all relevant interests into account, or rights in research into account, as well as the needs of research, and present these and in fora in fora in which the law is being developed. So it's really important that the research community put things like codes of conduct together, and that these are available to be inserted into the narratives, the legal narratives, as these narratives emerge. So, for example, it's important that organizations like GA4GH put together codes of conduct, and that these are circulated, and that these are presented to political bodies or potentially even jurisprudential instances or regulatory authorities, because the information and the knowledge at those levels about what is necessary in research and as to the sort of the ethical considerations that are relevant in research are going to be so much more specific and likely not in conflict with what sort of top level law says, that often they're going to be able to be inserted relatively easily into developing legal narratives. But they do have to be available, and they do have to be sort of put forward at the right times in the legal discussions, if that's clear. I hope I answered your question. I feel like it was a rather involved question.
Dara, I think that was a wonderful answer. Thank you for that. And Diana, Simon, Claudia, I don't know if any of you wanted to jump in and respond to Dara's point.
Not specifically. Can you see the screen I have or not?
I can't.
You can't. Okay. So.
No.
See why.
Meanwhile, please don't forget to enter your contacts in our document. as well as take some time, keep the link, take some time to look at the questionnaire that we have prepared.
One follow-up point to what you said there, Dara, was that I think that you're correct in that organizational and institutional practice is sort of already starting to have a circular relationship with the GDPR, in the sense that people are changing their practices because of data privacy law, but also common understandings about what should be considered anonymized, when you can share data, who you can share it with, seem to be starting to emerge. And another thing that I've noticed is that there are certain assumptions baked into technology, in the sense that when we use information, we assume that it's not necessarily possible to maintain privacy and utility at the same time, that the more you anonymize data, the more you lose data quality. But I think that the emergence of data protection law has really pushed investment in technologies that sort of break those assumptions. So for instance, things like distributed computing, secure multi-party computation, new technologies that might sort of push the health research community out of this sort of imbroglio, where there seems to be real trade-offs to be made between privacy and between useful research activities. I was wondering, Claudia.
Yeah, that's. I hear echoes in my talk. Oh, now can you hear me? Can you hear me?
Yes.
Throughout all these years, because I have multiple hats and multiple roles, I coordinate groups, I coordinate networks, I am the university's data whatever, and I'm on the RDA Council. And throughout all of these roles, and I'm a computer scientist, there is this continuous, I do not want to call it tension, but I cannot think of another word, between the technical, the ethical, and the legal aspects. And depending on the research domain, there's still the researchers. So and I found this in many countries, it's not just here, that sometimes there is no consensus. Sometimes you find the technical people saying, this is not an issue, tell me what you want, and I'll anonymize, I'll hide the bits and bytes that you want. It's just a matter of algorithms, just a matter of networks, and you think about your ethical and legal problems. But then if the technical people do not understand what's behind, they'll implement things that are not well specified, because the other side, okay, the other is the non-computer scientists, they did not specify whatever had to be done in a way that it could be appropriately implemented. Okay, so this is a problem that I keep finding. And on the other side, you have the scientists and the lawyers and whoever else, the ethics committees that are running all over, like the referees in my slides, the soccer referees. They are trying to find out what to comply with and how. And so this is not only legal and ethical, it's a mix of everything. But this is just a remark that I want to add. And it may be in your countries that implement GDPR that this also happens. But here it's also a matter of the way institutions work. So each institution wants to add their own practices. And this also complicates the issue. I'll just turn myself off to hear what other people have to say.
And sorry, Claudia, thank you for those comments. Anne has brought up the results of this
Okay.
first user survey, and I notice already that Claudia, you spoke to this sort of interdisciplinarity, and I think we're already seeing it just in the composition of the audience that's here today. So I'll leave the floor to Anne to discuss that.
Okay, so my microphone is on. Can you hear me? Can you hear me?
Yes.
Fine. So a number of you have answered the first question, which was to have an idea about who we were in this session. And we can see that we have data managers and researchers, and then some other, which is not right. What can be done now is to go to the next question, being is to know how has your institution been involved in collection, data sharing, data access. So the data sharing and data access issue, the most commonly encountered in this. And now we have the question, which is, for what purpose do you wish to share or access data? Can you go and vote on that, the people in the session? So there are different options, and you can it's not restricted to one answer.
Now, Anne, for me, it seems that we're not able to vote on that question. I'm not entirely sure why. I also wanted to draw very quick attention to two comments from the audience here.
Yes.
And I think Lars really does, say it as sort of concisely and eloquently as can be. That there's that sort of complex landscape between technology users, technology providers, and regulators. And it's hard to bridge, not only because they tend to use different specialized vocabularies, but also here there really are different cultures, different goals, different practices, involved at the technical level and at the level of what people are looking to do. So I think this speaks to what Dara said earlier, that we're not sure what we're trying to do with data protection law, and that because our objectives are still in development, it can be hard to know how to comply with the rules when we're not sure what we're trying to get out of them. And then here we have, I hope I'm pronouncing this correctly, Moni, who's basically stated that there's been a lot of focus on sharing across EU, EEA borders, and that there are researchers in Asia who are contractually required to work within the context of GDPR requirements. And so that there is this Brussels effect, in the sense that GDPR requirements are sort of starting to spread across other national boundaries and affect data uses, even if they are internal to countries that aren't working directly with or in the European Union or the European Economic Area. And speaking very briefly from my own experience, we've seen that in Canada as well, but GDPR conceptions are starting to infiltrate and affect our local practices. And here a little more clarification that it really is a question of sometimes where funding is coming from. So thank you both for those really interesting contributions. I don't know if anyone would like to respond to that amongst the speakers.
Alexander, this is Claudia again. It's just that I keep reading some of the side remarks, and I'd like to add to the fact that since Brazil is a leader in research and in South America, South American countries are now joining Brazil in creating their own data protection laws, which are being inspired more or less by GDPR, but which inspired our law. So it comes back to that European laws and practices influencing countries which in some cases do not even have established data sharing practices and mechanisms. So this is causing an additional level of complexity to the whole. Over.
Yeah, I was just going to jump in actually on the point Lars made around the tensions between those various groups, and I think that one of the tensions that perhaps we haven't spoken to too much is that, in my perception anyway, that researchers very often feel that the data protection laws are there to protect against intruders or people who seek to use the data in the wrong way. And so I think there is a slight disconnect there, because researchers feel that they are not people using data in the wrong way, but actually they're trying to make a positive social contribution in some way quite often, and so there's a slight dissonance between them feeling that the law is really there to try and prevent people not like them, rather than seeing some data protection law anyway as a gateway to enable their research to happen. So I think that ends up being something of a tension, that it's seen as something which is blocking people, blocking them in order to protect from other types of people, and not necessarily enough appreciation for how the law can facilitate research. If we think about the legal gateways that are available in GDPR, or even the guidelines that can help shape international transfers of data.
Yeah, I was going to say, I think both you and Claudia are pointing to maybe one of the issues on a normative level with the framing of the GDPR, in the sense that the sort of tension between the data user and the individual concerned by the data really does reflect its framing for a state surveillance context or a commercial processing context, where there's a disconnect between the interests of the data custodian and the interests of the individual concerned. Here in Canada, there's been a brief move to remedy that. In a new law that they're drafting, they're trying to create this new role for people that act on the behalf of an individual concerned by data. So really a custodian that's more a steward, rather than a sort of adversarial framing. And I wonder if this might be useful for the clinical and research contexts.
Yes, I mean, certainly that's the attitude that we've tried to cultivate with our researchers.
One last remark, because I keep feeling the need to share some of the very different things we do here in Brazil. Brazil is a very data-rich country. And I'm going to post a link to our public curriculum vitae database, which has millions and millions and millions, about 40 million of open curriculum vitae that are interlinked and linked to everything. And this is a compulsory database. If you want to get funding from anywhere, you have to contribute to this curriculum. And the second thing is that we are all public employees. They have to open their salary sheets. It's all in the open. It's not just how much we earn. It's whether we pay alimony or not. It's whether we have discounts for any kind of health plan. And at the same time, they're closing personal data. So isn't this personal data? It is, but everybody in the country can see how much I earn and how much I discount for health insurance, for instance, which if you work in the private sector is not open. So there is this tension between GDPR and whether this kind of data isn't it private data? Let's close it. And then they say, oh no, there are laws that are above the data protection law. Okay, and the public data government law is above data protection. This is just one funny thing here in Brazil. I'm so sorry, but I thought this would.
Can I just jump in? Because there's some. Sorry, can I jump in, Alexander? Is that okay?
Absolutely, please. I was hoping that you would.
There have been so many points raised in the past sort of few minutes that I'm trying to come up with answers to them, all of them, and then I tried to come up with one answer that answered all of them, and I couldn't. So I just want to sort of make an observation that we have talked in this session a lot about GDPR and GDPR clones and what the GDPR is and what it isn't. It's a million different things at the moment, and none of the descriptions that I've heard are full descriptions of what the GDPR or GDPR comparable laws actually are. It depends on which country you're in. It depends on who you're talking to. It depends on the perspective you take in looking at the GDPR. For example, Alexander, you've said it applies to research, but it was designed on the basis of adversarial relationships between data subject and surveillance mechanisms or bureaucracies or economies of scale. This is true. But when you look at it in the research context, there are also an absolute ton of exceptions. Claudia, when you talk about sort of the GDPR clones, and it's the GDPR that is causing certain problems because it's just been dropped into the Brazilian context. You could as easily say, and I'm not from Brazil, so perhaps I'm completely wrong, but I would imagine you could easily say as well, it is as much of a benefit to be able to take a template law from another jurisdiction, which for the most part embodies relatively sensible norms about how you go about dealing with somebody else's data. So don't process it in an inaccurate manner. Don't do this, don't do, or don't take more than you need. De-identify if you can, but you don't have to. But of course, there are all these exceptions because we don't know what we're doing yet. And then sort of in terms of how we use it in the EU and what it does and doesn't allow researchers to do, you have various different interpretations by country that take very different approaches to the use of the GDPR as a tool to facilitate research. So in the UK, and I think in Sweden, but I don't want to say too much about Sweden, you have this certain interpretation of the GDPR, which in fact allows data processing, which if you were only looking at the instruments of medical research ethics, wouldn't necessarily be possible. So the idea of just, well, actually under the NHS, that you can just process all of these different types of personal data for research under a public interest justification. That's not possible under a number of interests, a number of instruments of well-regarded medical research ethics, although the UK does actually, sort of the NHS does require ethical consent over and above. That's a way of using the GDPR that actually facilitates research and allows research or provides facilitators to research that wouldn't exist even under more strict sort of principles of medical research ethics. It's a legal construct that is in an extreme state of flux, and we have to be careful when we say it is or isn't that, because we risk miscategorizing it, and this miscategorization leads to misunderstandings, which lead to criticisms that often aren't justified in specific cases. I mean, sometimes they are, but often they're not.
Yeah, I mean, James in the chat has raised a really interesting point there around the using data protection or selling it to researchers essentially as a way of protecting research participants. And I think it was a point that I was actually going to make myself around the role of the data subjects or the research participants in data protection. And I think that's one thing that the increased awareness of data protection law and how it's become more prominent has been a benefit, actually, because I think people are more interested in the way that their data is being used, and in doing so, very often they're very good advocates for the way that their data is being used. If I think back to my experiences in the UK, it was at times quite a lengthy process in order to access patient level data, necessarily so, because you don't want it to be just open for everyone to use. There was considerable push from patient groups and patient advocates to improve that situation, because their feeling was, it's our data, we want that data to be used for the benefit of society at large. You need to improve your system so that it can happen in that way. And I think sometimes as researchers, we overlook the patient voice or the data subject voice as being both advocates in favor of research, but also considering as well, and it's something I try to think of when I'm doing my work. Would I be happy for my data to be treated in this way? And if I feel that I would be, the chances are I'm complying with the kind of ethical guidelines that we have to comply with and the law itself. If I would feel that actually, no, I wouldn't be happy or happy for data belonging to one of my loved ones being treated in this way, it probably means I'm doing something, that would be against the data protection laws as well. And so I think always thinking back to who the people are behind the data points is really good in terms of making sure you're working in the right way, but also don't forget them as a voice for advocating for better access to research data, because by and large, people want their data to be used for good reasons.
Simon, I think that's a really interesting comment. One thing I might add to that is that I think the emergence of this data privacy law in general has pushed communities to be more vocal in making value-laden choices about how their data should be governed. I think pre-GDPR, a lot of the conversations about data use revolved around using the data versus not using the data as a sort of binary. And I think that you see it a lot. Organizations, including these sort of open science or patient-initiated projects that are really working from the assumption that data should be used or that data can be used, but under what conditions and under what models of governance. And we're starting to see the emergence of a more sophisticated landscape, in the sense that some communities are sharing their data but stewarding it themselves, or some users are starting to express complex preferences, like about when they can be profiled or what sort of uses of their data can be made, but then opting out of others. So I do think that you're correct, and that Claudia and Dara's earlier comments are correct, that it is creating a more nuanced series of questions about what we can do with information that will eventually lead to a lot of individual agency in directing health research.
Can you hear me? That's Anne. There is a question in the chat asking whether there are in RDA public involvement groups. Maybe Claudia has a better overview as a member of the council. But what I can say at least is that within the RDA COVID-19 groups, there were one about community participation, which touched a bit of that. And then the social science group was very much working on the public involvement, public participation. So at least in these groups, this preoccupation was there. I'm not aware of other groups, but it might be that we have to check the list of the RDA groups or ask for the creation of one.
And just to add to that really quickly, our own legal ethical group is, well, maybe it's not addressing the experiences of public participants, but it is open to public participation.
I'm sorry, this is Claudia. All groups are open to public participation, but before you must become a member of RDA. You cannot join a group, and RDA has over 11,000 members, which are joined by their love of sharing data, okay, or data-related issues. Therefore, if there is no such a thing as telling everyone, come join our group, but you do not need to join RDA. Our groups are directed and towards RDA principles of openness, sharing, and other principles. So to join RDA groups, you have to you have to show that you consent to these principles of openness and others. We only have 39 seconds before they close it, so I'm muting myself for the last.
Just the quickest of comments that I might make is that if you drop your name in the Google document that was shared, and just mention that you're interested in participating, well, I think our group would be happy to reach out via email. And also, it's really simple to become a member of RDA. You just sign up online, to my knowledge. I see we have 12 seconds. Anne, any closing thoughts?
No, I think that in the Google document, that's quite important to look at it. And I would say that you can comment, make suggestions for the questionnaire that we will then send through RDA, but also in other communities until next Tuesday. So that then we can proceed taking into account your contribution. So the Google Doc will continue to be open. You have the link. It is in the description of the session, just over the agenda. And we hope that you will take some time in addition to the session to comment, and make suggestions, any input which will be there, or sent to one of us by email will contribute to the future work of the working group. And thank you very much for your participation, and very sorry for all the technical issues I had.
Yeah, I'd like to close with a really big thank you to all of our speakers, to our extremely engaged audience, and to Anne for her moderation efforts and for putting together that interesting poll, which has given us a lot of data to work with and think about in launching our survey. Thank you all.
Bye-bye.